very seldom would I ever allow somebody out on bond who I felt was incompetent. It's too difficult actually to do a competency when they're out.
Very seldom would I ever allow somebody out on bond who I felt was incompetent. That's a retired judge, on the record, reacting to a decision he didn't make. Sit with that for a second, because it's the entire case in one sentence. A courtroom veteran of 36 years looking at this file and saying, out loud, this isn't how it's supposed to work.
So to dig into the very latest on this case, I want to bring in retired Judge Robert Ruhlman. He was on the bench in Hamilton County, Ohio. That's Cincinnati. And he was on the bench for many, many years. So Judge Ruhlman, thank you so much for coming on.
Yeah, thanks. Yeah, I was elected judge for 36 years, got 6 terms. I was elected every time. I'm the longest serving common pleas court judge, general division in the history of Hamilton County. And then 3 more years as a retired judge. So
you've been around the block. You've done a number of cases, presided over a number of cases. What are your thoughts, first of all, on this case? I know you've also presided over cases out in the Vinton and Jackson County areas. So what are your thoughts? You hear about 16 children. The prosecutor says they were hidden from the world, found in a house where the authorities say it's full of squalor, feces, the whole 9 yards. And this family is all living together. What do you make of that as a retired judge?
I've had cases like that in Hamilton County also. And when I was years ago, when I was actually an arson investigator years ago, in a prior life, in the arson task force, I would go into houses during fire investigations and get fleas all over me and everything. People living in squalor. And I had a case where a mother actually let her kids, she was a prostitute, let her kids in the house while she was out prostituting. And they started a fire and they were overcome. They were actually revived. And then this liberal magistrate in juvenile court gave the kids back to her. And a couple months later, I responded, and we actually had to scrape these kids off the floor. They were literally melted. Yeah, they were killed. Yeah, it was horrible. I've seen a lot of bad parenting.
Now picture the exhibit that sits behind that quote: a single sheet of paper, a $300,000 signature bond, and a signature so unsteady it barely qualifies as handwriting. That shaky ink is the visual you need to hold on to for the rest of this video, because it's the physical evidence of a question nobody in this case has answered yet. Is this the signature of a man who understood exactly what he was signing, or the signature of a man who couldn't? Before we go deeper into what the records actually show, make sure you're subscribed to the Crime Infinity, because we don't just cover the story, we follow the evidence. Here's the exhibit. Gary Siders Sr., 73 years old, grandfather to more than 16 children, facing serious felony charges connected to 16 of those grandchildren, removed from a residence in Vinton County, Ohio, on June 30th.
Gary Siders Sr. is 73 years old. He's a grandfather to more than 16 children, and he's accused of serious felonies related to 16 of those grandchildren who were pulled from his home in Vinton County, Ohio, back on June 30th. Gary Siders Sr. has pleaded not guilty to the charges. So has his wife, Christina Siders, and his son, Gary Siders Jr., and his daughter-in-law, Elizabeth Siders. Of course, Elizabeth Siders is the mother of the 16 children, and Gary Jr. is the father. Right now, we don't know what the prosecution is saying Gary Siders Sr.'s role in, quote, hiding the children was. We just don't know. The county prosecutor and the state's attorney general have said several times that the family was hiding the children. Maybe
he has pleaded not guilty. So has his wife, Christina Siders. So has his son, Gary Siders Jr. So has his daughter-in-law, Elizabeth Siders, the biological mother of all 16 children. For adults, for not guilty pleas. And as of this recording, the prosecution has not publicly detailed what it alleges Gary Sr.'s specific role was in what officials have repeatedly called, on the record, an effort to hide these children from the outside world. That's the exhibit. Now here's the irony explosion sitting right on top of it. On August 4th, Gary Siders Sr. signed that $300,000 signature bond and walked free, not because the charges were reduced, not because evidence disappeared, but because the county says it could not afford to keep him.
Maybe we'll learn more about that at a later date. On Monday, August 4th, Gary Siders Sr. signed a signature bond, and you can see from his handwriting, the signature isn't the best, but it's there. Maybe that is because of his medical condition, or maybe he just has poor penmanship. We don't know. But Gary Siders Sr., it would appear, has been released from the hospital, and he has to follow a number of conditions, such as showing up for all of his court appearances, and he has to wear a GPS monitoring bracelet at the expense of the state. Gary Siders Sr.'s
His own attorney had already gone on record, weeks earlier, laying out specific concerns, confusion about the legal process, difficulty understanding the roles of the people in the courtroom, and inability to discuss the proceedings against him with any real sophistication. Those aren't a defense attorney's opinions pulled from nowhere. Those are documented observations made in open court during a preliminary hearing, visible enough that a lawyer felt obligated to put them in a formal filing. So here is the gap this entire case lives inside. The man was released because the county says he isn't dangerous, and in the same breath, his own lawyer says he may not understand a single word of the case being built against him. Officially, he's harmless. Unofficially, is he even present for his own prosecution? A forensic psychiatrist reviewing this case publicly pushed on that exact contradiction.
What was going on around him.
I asked forensic psychiatrist Dr. Daniel Bober about the decision to release Gary Sr. on a signature bond when questions about his competency remain.
Well, it must be a pretty serious illness if they feel like he's not a threat to the community, right? What's going on over there? Was he suffering from dementia? Did he have a stroke? Is it terminal cancer? Is it, end stage heart disease? Mm-hmm. It would have to be something pretty serious if they feel like, given everything that's happened and given the fact that he was sort of presiding over this, if you will, that he is not a threat. So that's what that tells me.
They're raising the issue of competency, though. So his attorney is saying, basically, I have concerns that Gary Sr., really can't assist me with his defense and isn't understanding the proceedings. And we all kind of saw it for ourselves during that first court appearance. What are your thoughts when looking at that piece of this puzzle? Because I'm like, well, you're saying he may not be competent and may not have the ability to understand the proceedings. He may have some type of mental disease or defect. You're having him evaluated for potential insanity defense, yet we're releasing him. He's not a threat, but also he may not be competent. Your thoughts on that part of it?
It could be some neurological condition where he's unable to make decisions or he lacks capacity. And then maybe they feel that in the care of a family member that he would not be a threat. And if they don't think he's a threat, that makes me feel like they're...
If the county is confident enough in his medical condition to call him no threat to the community, that condition would have to be serious enough to raise real questions about whether he can assist in his own defense at all. Dementia, stroke, late-stage disease. The public record doesn't say which. What the public record does say, on the county prosecutor's own words, is that his ongoing medical care could potentially bankrupt Vinton County, a rural county running on a budget smaller than a single department in most cities.
We still have no idea what serious medical condition Gary Sr. suffers from, but the county prosecutor has said previously that he's not concerned about Gary Sr. being a threat.
First, let me stress, the community is not at risk because of this bond. That Mr. Siders Sr. has a serious medical condition that requires specialized care in a hospital outside of this area. The county was going to be on the hook for his medical care. And again, based on the information that we were provided, his medical care could potentially bankrupt Vinton County.
A poor county, a serious illness, and a defendant's competency colliding in one bond hearing. That collision is not incidental to this story. It is the story because Gary Sr. was never the only name raising this issue. This is the parallel narrative that turns a single defendant's case into a pattern investigators can't ignore. His wife, his son, and now, most recently, his daughter-in-law Elizabeth, the mother of the 16 children removed from that house, through her own attorney, has formally requested a competency evaluation, along with a separate evaluation into whether she could pursue a not guilty by reason of insanity defense.
Lawyers for all four Siders family members are raising the issue about whether their clients are competent to stand trial. Yes, Now all 4 of them. Just today, Elizabeth Sider's attorney filed a motion asking for a competency exam and an evaluation to see whether she could qualify as not guilty by reason of insanity. Tommy Stolley wrote, "As of the filing of this motion, the defendant has not been indicted, and therefore counsel does not have all of the facts, evidence, or circumstances of this case or the defendant's subsequent arrest. However, in the interim, counsel has met with the defendant on numerous occasions and for extended periods. During these interactions, counsel has been able to observe the defendant's demeanor, conduct, and comprehension. These interactions lead counsel to believe that the defendant may be suffering from significant mental health issues and that competency may be an issue and a clear impediment to the defendant's ability to assist in her own defense."
Her attorney's filing states plainly that extended, direct interactions with his client led him to believe she may be suffering from significant mental health issues serious enough to impede her ability to assist in her own defense. For defendants, one household, for separate claims that none of them may be capable of standing trial. Ask yourself the question this case now forces onto the table. If a household of 4 adults can simultaneously claim incapacity to understand 16 felony counts, does the system pause for all of them? Or does it have to prove, one competency hearing at a time, which of those claims are real and which are strategy? This is where the hard evidence comes in. And it's the part of this case that should genuinely unsettle you, because it's not theoretical. Competency claims in Ohio, like almost everywhere, aren't taken at face value. Jails run cameras constantly, in the day room, at meals, during interactions with correctional officers and other inmates. When a defendant appears confused and disoriented sitting across from a court-appointed psychiatrist, but appears alert, coordinated, and fully engaged on unmonitored footage from the same week, that gap becomes its own kind of testimony. Add in recorded jail phone calls, which every inmate is warned about, and which every inmate somehow still forgets are being recorded, and you get a second layer of scrutiny defense claims have to survive. People have confessed on those calls. People have coordinated alibis on those calls. And people have, on occasion, admitted to faking symptoms on those calls. That's the mechanism that now stands between 4 competency claims and 4 competency rulings.
Yeah, and I think that's a good point because Elizabeth Sider's brother has posted on Facebook that he thinks the other ones are faking it. He thinks that
they're all faking.
Yeah. So he thinks they're faking being goofy, as he put it. So what do you make of that? How common is that somebody would raise a competency issue?
It happens a lot, and it happens a lot, and the issue with cameras have helped a lot. We have cameras everywhere now. We didn't have cameras years ago. I remember I was on a federal robbery task force, and that was before cameras, and we had to go on eyewitnesses and forensic evidence, and it was tough. But now there's cameras in every bank. You don't have many bank robberies anymore. There's cameras all over. Somebody commits a crime. Somebody broke into a jewelry store yesterday. They have those cameras. Every house, they followed the car with using the cameras and found out where they were and arrested them. So, so the cameras in the jail will constantly be used to monitor them. So they'll fake in front of the psychologist. Then they let the cameras run, and the psychologist then reviews them when they eat food, when they interact with other inmates, when they interact with other correctional officers, and clearly it will show that they're fine. They just act goofy when the psychologist shows up. So it's very important to keep them, at least during the competency. He should be held until they determine competency. I don't know about the
faking incompetence is a documented strategy. Genuine incompetence is a documented medical reality. The cameras don't know which one they're looking at until someone reviews the footage. Here's the phrase to hold on to, because it's going to come back. The system let him walk before it answered the only question that matters.
Well, that's another issue. I never would allow, very, very seldom would I ever allow somebody out on bond who I felt was incompetent. It's too difficult actually to do a competency when they're out. There was a couple cases where they were people that had some real bad mental problems and didn't commit a very serious offense, maybe a felony drug abuse or something like that. And they obviously had mental problems and they were not a threat to anybody. And they were low-level felonies. I would let them out. Usually they would end up going to a halfway house or something like that. But in a situation like this, these serious charges, he's claiming he's incompetent. A lot of defendants fake it. They try to fake it. A good examiner will have them watched and will review video of them when they're not there and pretty much clear up the faking. Because a lot of times when they do the interview, they'll fake, but they record them in jail and how they interact with other people. And then suddenly the psychologist or psychiatrist shows up and they act goofy, Well, they are obviously faking. But the only way you can do that is I would have at least kept him in for the competency evaluation, because then you can monitor whether they were faking or not, because they have videos in jail going all the time.
That's not commentary. That's the sequence of events as the record shows them. Bond signed. Release granted. Competency still unresolved. The system let him walk before it answered the only question that matters. Let's lay the timeline flat, because in a case with this many moving parts, the order is the story. June 30th, 16 children removed from the Vinton County residence, for adults taken into custody. Shortly after, all for plead not guilty. In the weeks following arraignment, Gary Sr.'s attorney raises competency concerns publicly, citing direct courtroom observation. Gary Sr. is hospitalized for an undisclosed serious medical condition. August 4th, he signs the $300,000 signature bond, is released under GPS monitoring, and returns to either family custody or a medical facility. The record isn't fully clear which. As of this recording, Christina Siders, Gary Siders Jr., and Elizabeth Siders remain held in the Southeast Ohio Regional Jail on $300,000 bonds each. Elizabeth's competency motion is the most recent filing in the case. No indictment has been handed down. According to her own attorney's filing, the defense doesn't yet have full access to the facts and evidence the eventual charges will be built on, meaning everything discussed publicly so far is still just the opening chapter of what prosecutors intend to present. One detail deserves its own moment, because it may end up mattering more than any competency hearing. School records reportedly listed these children as homeschooled.
Because they were evidently hiding them. And the whole thing was that they were supposedly homeschooling these kids. Is that right?
We don't know. That's been suggested on social media, but we don't know that was actually happening. They certainly weren't registered for homeschooling.
No, but they had a thing in there where they said they went to their school record. They said homeschool. So they must have told them they were going to homeschool them, but they didn't monitor them at all,
Right.
But that was the excuse. Because you wonder what they weren't in school. Why weren't they being monitored? Where's the truant officer, but they evidently said they were homeschooling them, but then they didn't monitor that either. It's just
there is no public confirmation that the family ever formally registered for homeschooling with local authorities. No documentation of instruction. No oversight. If that holds up, it means a label, homeschool, was enough to make 16 children invisible to every institution that might have checked on them. The system let him walk before it answered the only question that matters. And somewhere upstream of that, the system also let 16 children vanish from its records before anyone asked why. So where does that leave this case today? 3 defendants in custody. One out on a bond secured by nothing but a signature no one can fully read. For separate competency claims moving through evaluations that Ohio law generally allows 30 to 60 days to complete, with the state entitled to request an independent second opinion if it disputes the findings.
That was going on with this. So how do you think that the competency evaluations, do you think that slows this case down at all?
Not really. I mean, it happens a lot. They try to do them within 30 to 60 days. And then they have a hearing, and usually they stipulate, if the person that was found competent, they stipulate to it. If found incompetent, then a lot of times the state will ask for another examiner, Sometimes the examiners they have that work for the court are a little naive, and they'll bring an independent examiner in. I would depend. There's a couple really sharp examiners who catch these people that fake, and I would always depend.
That's not a fast process. That's not meant to be a fast process. It's meant to be a careful one, which means the real verdict in this case is still months, possibly longer, away. The system let him walk before it answered the only question that matters. 3 times now. Because it's the one sentence this entire case still hasn't outrun. If you want to follow this at the source instead of waiting for headlines, the Vinton County Court of Common Pleas maintains a public docket where every competency motion and bond filing in this case is entered as it happens. Read it yourself. And tell us in the comments, if a defendant is medically fragile enough to be called harmless, should that same fragility automatically raise doubt about whether they understood what they signed? We want to know where you land. If this breakdown gave you something the headlines didn't, hit like, share it with someone who follows cases like this closely, and subscribe to the Crime Infinity. Turn on notifications, because as new filings land in this case, we'll be reading them before anyone else brings you the headline. We'll see you in the next one.